Good evening, friends. Welcome to my YouTube channel, Advocate Amit Kumar Gupta. In my series on the income tax cases, the case which I have picked today for deliberation is the case of the Bombay High Court, which has been decided in a writ petition. The name of the case is FARMACIA, MOLIO versus Income Tax Officer and others. This case has been reported in 44 ITR at page number 65. The case has been decided on 31st January 2022. Friends, again, this case is on section 148 notice. The facts of the case are very clear. In this case, a notice under section 148 was issued to the assessee, alleging that there is a cash deposit of more than 4 crore into the bank account of the assessee, and the assessee has not filed his income tax return. That is why it is a good case of income escaping assessment, and the notice under section 148 was issued. The assessee raised the objections. The department disposed of the objections by a speaking order. After disposing of the objections by the department, the assessee received a letter from the bank that the bank account which was alleged, in which the cash was deposited by the assessee, does not relate to the assessee. This fact came to the notice of the assessee by a letter which has been received by the assessee from the bank, because when after receiving the notice, the assessee went to the bank, he inquired about the bank account in which the cash was deposited. So the assessee came to know through the letter of the bank that this account does not relate to the assessee. The assessee challenged the notice under section 148 before the Bombay High Court that this bank account does not relate to me, and the department has not considered this fact. So the assessee prayed before the Bombay High Court to quash the notice under section 148. But the Bombay High Court said that the point of the assessee that the department didn't consider the letter of the bank is not correct, because this letter was not brought to the knowledge of the department before disposing of the objections of the assessee. This letter was presented directly into the High Court by the assessee. So the point of the assessee is not correct. So the Bombay High Court denied to interfere into the notice of section 148 issued by the department. The Bombay High Court quoted two very important decisions of the Supreme Court. One case is New Delhi Television Limited versus Deputy CIT 2020, and this case has been reported in 424 ITR at page number 607. In this case, the Supreme Court said that the notice under section 148 is valid if the notice and the material with the department on which this notice is based have live link. If the material is there and the notice is there and there is some connection between the two, then the department can issue the notice. This is sufficient to issue the notice. Whether this material is sufficient or not doesn't matter. But if the material is there and the notice has been issued, then the department has wide powers to issue that notice. Apart from that, the Supreme Court also gave reference to a very important case of the Supreme Court. That case is Fulchand Bajranglal versus ITO 1993 203 ITR 456 page number. In this case, the Supreme Court said that at the time of issue of the notice, only it is to be seen that there is some material, there is reason to believe to issue the notice. Whether those reasons are sufficient or not, whether that material is sufficient or not, should not be the job of the High Court to test. The High Court cannot test in a writ petition the sufficiency of the reasons to issue the notice. If the reasons are there, if the material is there, then the matter is over and the department has a power to issue the notice under section 148. So the High Court cannot test the sufficiency of the reason at the time of issue of notice. So in this present case, the Bombay High Court dismissed the writ petition by saying that no prejudice to the assessee will happen if the assessment will be there. At the time of the assessment, the department have to consider the letter which has been received by the assessee from the bank that this bank account does not relate to the assessee, and the Bombay High Court denied to interfere into the notice issued by section 148, and also directed the department to consider that letter which has been received by the assessee after the disposal of the objections by the department. Friends, although with due respect to the Bombay High Court, this decision is a welcome decision, because in this decision the Bombay High Court told the department to consider that letter. But since nowadays we see that when the procedures are not followed by the department, the matter is remanded back to the department. So in this case also, a more justice can be done to the assessee by remanding back the matter to the department and consider the letter. That should have saved the assessee from in this vicious circle of litigation, because there are very weak chances that the department can do the assessment at nil, because this bank account was not relating to the assessee in fact. But with due respect to the Bombay High Court, the Bombay High Court gave the relief to the assessee by giving instructions to the department to consider the letter issued by the bank to the assessee that this bank account does not relate to the assessee. Friends, at the end of this video, I am once again repeating the name of the case. The name of the case is FARMACIA MOLIO versus Income Tax Officer and another. Thank you, friends.